So there's an attorney for one side, an attorney for the other side. If it's a criminal case, it's a federal prosecutor, and the defendant is a criminal defense attorney. And what we see is that we have witnesses, we have testimony, we have lawyers conducting direct examination and cross-examination. Evidence is introduced. There's a single presiding judge. And most often there's a jury. Now, not all cases have a right to jury. All criminal cases do, but not necessarily all civil cases. There's a subset of civil cases that are referred to as cases in equity, and you don't have to know that term, cases in equity, in which you do not have a right to a jury. So these are the kind of cases that we become most familiar with, the kinds of procedure that most, when the movies deal with the legal system, introduce you to. And in the United States, we have divided up our country into 94 federal district court regions. 3?
93.
I've been corrected, it's now 93 federal district court regions. And each state has at least one district court. So in other words, you have one that would deal with all the federal issues within that particular state. And no state has more than 4. Each district court is composed of at least one district court judge. But some states have as many as 27 district court judges. And what determines how many district court judges there are? The number of legal issues and cases that come before them. So it's determined by the legal workload. So for example, Montana, which has a very small population, doesn't have many legal issues. Who ran over the beaver or something? I mean, that kind of thing. You only need one judge, and they can deal with all the legal issues of that state. The Southern District of New York, which encompasses New York City and Wall Street and media and everything else, has thousands of cases, so therefore they have numerous federal district court judges. Now, when we say there's more than one federal district court judge, that doesn't mean they all preside with each other at the same time. No, each one has their own courtroom and it presides individually over the cases before them. So the thousands of cases are assigned to that district and then divided up equally among the judges. Now, how do the judges get their job? Well, for federal district court judges, we talk about the idea of what's referred to as senatorial courtesy. And senatorial courtesy is the method by which we select judges. Now, district court judges, as are Court of Appeals judges and Supreme Court judges, are all appointed by the President of the United States. But for district court judges, it's with the consent and the involvement of senators. And once these people are appointed, they hold office for life. So this is a great job if you can get it. The only way you lose your job is when you die or you resign or if you're impeached. And those things don't happen too often. Well, at least the impeachment part. So how does senatorial courtesy work? Well, let's assume there's an opening in the state of Ohio on our district court. And we have 2, by the way, the Northern District Court and the Southern District Court. The president would then contact the senior senator from his party in that state and ask for nominations. And the reason you do that is the president doesn't know who are good lawyers or good state judges in every state. So they go to the senior senator of their party. Now in this case, the senior senator from Ohio is Sherrod Brown. Would he go to Sherrod Brown? Heck no, because Sherrod Brown's a Democrat. So clearly Donald Trump would feel as though he's a communist, so he can't go to Sherrod Brown. So he goes to the junior senator, Rob Portman, who is a Republican, and would say, Senator Portman, please tell me 3 or 4 people who you think we could nominate for this position. And then his Justice Department would look at those nominees, vet them, do background checks, and the president would decide from among that group. So that's what we mean by senatorial courtesy. And that is the first approach and the first level of federal courts. The next level are the United States Court of Appeals. Now, the United States Court of Appeals is entirely an appellate court. So in other words, it doesn't hold trials. It's an appellate court. It's never the court of original jurisdiction. And although a few kinds of district court decisions can be appealed directly to the United States Supreme Court, most have to first be appealed to these courts of appeal. Now, the United States is divided into 12 appellate circuits, with each consisting of between 3 and 15 permanent judges, plus there's a circuit for District of Columbia. So they have, again, 3 to 15, depending upon the amount of cases that are in those different areas. The United States Court of Appeals, as we said, has only appellate jurisdiction. It can never be a court of original jurisdiction. So as we said, in 2010, 376,000 cases were brought to the district court. Now the question is, how many get to the Court of Appeals, and how do you get to the Court of Appeals? Well, to get to the Court of Appeals, you must file an appeal. And the appeal must show that the district court made some kind of error that is prejudicial. In other words, it can't be just some silly clerical mistake. Oh, they spelled my name wrong. But it has to be something significant that could have influenced the outcome of that case. They allowed evidence in that they should not have allowed because it was a violation of search and seizure law or my Miranda rights. So as we said, depending upon a court of appeals, they can have anywhere between 3 and 15 permanent judges. As of 2017, there are 167 Court of Appeals judges. Now, the United States Court of Appeals must hear all properly filed appeals. So in other words, if you do have a legitimate appellate issue and it is prejudicial, the Court of Appeals must hear it. Now, interesting enough, out of these 376,000 cases, only 56,000 are ever appealed. And as you can see, that's a very small number. It's less than 2%. So most cases do not get appealed. And as a result, the district court is what we refer to as not only court of original jurisdiction, but the court of last resort for most cases. Why do such a few amount of cases get appealed? Well, one of the major reasons is cost. It costs a lot of money to appeal a case. You have to hire an attorney who then has to purchase all the court transcripts, go through it, find all the errors, research all the errors, then present all this to the client, appear before the Court of Appeals to argue the case orally, to write all the appellate briefs. So it is not unusual for an appellate brief to cost a person tens of thousands of dollars. And at that point, especially if it's a civil case, they say, is it really worth it? How strongly do you feel that the court really made a mistake that's going to make a difference? And depending upon how much you're suing for, so if you're only suing for $100,000, and it's going to cost you tens of thousands of dollars just to bring the appeal, is it even worth it financially, even if you win? So for those reasons, those very practical reasons, again, the number of cases that are appealed are very small. Now, a Court of Appeals hearing is very different in terms of procedure than the district court. And they're much less familiar to the average citizen than the district court. So the appellate hearing, there are no jurors, there are no witnesses, there's no direct examination, no cross-examination, no introduction of new evidence. The way it works is both sides file appellate briefs. The judges then read these briefs, or probably more accurately, their clerks read these briefs and do research for them in terms of what are the major legal issues and what's the law in that area. And then what happens is you have the appellate hearing. And in the appellate hearing, and I've done one or two of these, this is a very intimidating process. So you come in, you are asked to go behind this really small podium. The judges, and it's usually, as I said, a panel between, say, 5, 7, 9, it can be a lot of people, sitting on an elevated stage and looking at you. And they have their briefs, and they have all these brilliant clerks who've analyzed every aspect of the case for them, so they probably know the case better than you do at this point. And you go in, and you, as the person who's filed the appeal, think about what you're saying. You're saying, I, as the attorney for my client, know the law better than the district court judge who ruled on this case. They made a mistake. Okay, so right off the bat, you're telling them you know more than judges, which some judges don't like that idea. The other thing you have to remember is that many of the Court of Appeals judges were district court judges first. So these are their comrades. So you better really show that there was a huge mistake. So you get on this, behind this podium, you present your cases, and they get to bombard you with questions. Well, Mr. DeSario, you said that this is a violation of Miranda rights. Well, isn't it true we came up with an exception to this in the case of Jones versus Doe that said for these reasons you don't have to give Miranda rights? And you got to answer all these questions. And they berate you and ask you questions one after another, and you get confused sometimes. And you don't control the court like you do in the trial courts. That's where the attorney's king. They can move around, they can point fingers, they're the ones who put people on the stand and ask the questions. The judge can't play any role in that except to either uphold an objection or to overturn it. So this is a totally different situation. So I can remember when they started bombarding me with questions, I started to get a little nervous. And I started walking. You guys know I like to walk. And the judges reprimanded me. They said, Mr. DeSario, will you please stay behind the podium and stop using your hands? Tell an Italian not to use their hands when they're talking. You might as well cut my arms off. So it's a very different kind of environment. As much as we attorneys like the district court and control it, that's how much we don't like, for the most part, the Court of Appeals. Now, some of my friends liked it, but most of them didn't. So then, eventually, after you do this oral presentation, the Court of Appeals decides the case. And because there's multiple judges, there's three terms that you really have to understand. The majority decision, the dissent, and concurring opinions. So the majority decision consists of the majority of judges who hold one way or another in this case, and that becomes the binding decision. The dissent are people who just disagree with that approach, maybe from a legal basis or factual basis. And a concurrence is you agree with the outcome of the majority, that certain things should happen, that maybe this was a violation of Miranda rights, but you have a different legal explanation for it. So those are the three kinds of opinions you can have, and if you really want to get into this in great depth, we talk about this a lot in Intro to Law. I'm going to leave it at that for the purposes of our class. Well, that's not necessarily the end of the federal legal process. So if you don't like the decision of the Court of Appeals, you can then appeal it to the United States Supreme Court. And as we said, there's 56,000 cases that go to the Court of Appeals. Then when we look at the Supreme Court, out of those 56,000, on average between 80 and 100 are actually heard by the United States Supreme Court. 80 or 100. That's not too many cases. And why and how does that work? Well, when we look at requests for review, the number varies, but somewhere between 7,000 to 10,000 reviews to the United States Supreme Court. But the Supreme Court, as an appellate court, has something that the United States Court of Appeals does not. It has complete control over its docket. What does that mean? What it means is, if the United States Supreme Court doesn't want to hear a case, it doesn't have to. So how does something get to the United States Supreme Court? It's through what's referred to as the Rule of 4. So before the start of every Supreme Court session, they have a judicial conference, which one of our students actually had an opportunity to witness and be a part of, and that's Quentin Rock, who's also filming these sessions for me. And they present to the judges a summary of their cases with recommendations. And then the judges get to vote. And only if 4 judges decide to hear the case will a writ of certiorari be issued. And a writ of certiorari means send up all the papers in regard to this case. But if 4 don't hear it, doesn't matter if it's the most important case in the world, they just don't want to hear it for whatever reason. Maybe it's too controversial, too complex, whatever. You don't hear it. You don't hear it. So the justices, Supreme Court justices, are in session from the first Monday in October through June. There are 9 Supreme Court justices, and they also, like the Court of Appeals justices, are appointed by the President of the United States for life. The United States Supreme Court is an unusual court in that it has appellate jurisdiction, but according to the Constitution, it can also have original jurisdiction, but only over a few specified types of cases, such as cases involving foreign diplomats, disputes between states, and disputes between states and foreign governments. And even for those cases, they can delegate them elsewhere if they want, and I don't want to get into it because that's pretty complex. As we said, generally the justices hear fewer than 100 of the thousands of cases that are annually presented to them. How do they decide? Well, again, I'm not getting into a lot of depth. If you really want to get into this in a lot of depth, take my intro to law course or my con law course. But they will generally review a case only if they believe it has broad public significance. Now, if they refuse to hear a case, they refuse to issue a writ of certiorari, it doesn't necessarily mean that the justices agree with the decisions of the lower courts. Like I said, it just might be too controversial. They might not understand how to resolve the case. We had that with abortion for many years before they heard Roe v. Wade. And if they do not hear the case, what that means from the federal level is that the U.S. Court of Appeals, if it's a federal case, whatever that Court of Appeals decided, that becomes binding law. If it went through the state courts, then what the state Supreme Court to that point has said about it is upheld. So that's the federal court organization. And I think I'll stop here. And next time we meet, we'll talk very briefly about state courts, and then we're going to talk about the whole idea of Marbury versus Madison and judicial review and the powers that gave the United States Supreme Court. Have a great day.